Good morning, Lord Evans.
Good morning.
Thank you very much for making the time to be with us. You have a busy schedule, I know, and we're very grateful that you can fit in this session with us. Let me explain the arrangements to you. You are talking not just to those in front of you, who are a mixture of participants, core participants, and public, but beyond this room, to a number of others who will be watching on YouTube or live stream. On your left, there are lawyers behind Ms. Richards, who is standing and will ask you the questions, who represent various different interests in the inquiry. At the back on the left, there are members of or representatives of the press. So that's your audience. Yesterday, it numbered over 300 in total. And it will be very similar today. So that's the constituency, if you like, that you're addressing through the questions asked by Ms. Richards. In a moment, Mary will invite you to take the oath, and then Ms. Richards will begin.
Please state your full name.
My name is Jonathan Evans.
Take the book in your raised hand and repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Lord Evans, just by way of your background, you were Director General of MI5 between 2007 and 2013.
That's correct.
And that followed a long career in the security services from 1980 onwards.
That's correct.
You became a crossbench life peer in 2014.
Yes.
And then in November 2018, you became the chair of the Committee on Standards in Public Life for a 5-year term.
That's correct.
And it's in that capacity that you're giving evidence to us today.
Thank you.
Can I just ask you to tell us a little about what the Committee on Standards in Public Life is and what it does?
The Committee on Standards in Public Life is an independent, non-departmental standing committee. It is sponsored by the Cabinet Office, and the chair and members are appointed by the Prime Minister. The role of the committee is to advise the Prime Minister of the day on ethical standards across the whole of public life in England. We monitor and report on arrangements for upholding ethical standards across public life. We do not have a remit to consider individual cases, and we therefore do not investigate breaches or alleged breaches of the rules, and we are not a regulator, but our role is to look at the way in which the rules for public standards are articulated, are laid down, and the arrangements for enforcing those, and then to provide advice to the Prime Minister on any areas that we believe need to be adjusted. The committee is comprised of political members, so we have representatives currently of the Conservative Party, the Labour Party, and the Liberal Democrats, and also in a majority by independent members who are appointed through the public appointments system, and I sit as an independent member not representing any party political interest.
And so part of the committee's raison d'etre is to promote the Nolan principles, the 7 principles of public life. Is that right?
Yes, the Nolan principles were laid down in 1995 by Lord Nolan, who undertook an inquiry at the invitation of the then Prime Minister, Sir John Major, and he articulated the 7 principles of public life, and our committee, as it were, takes responsibility for those principles and works to promote them where we can. Obviously, we are not a campaigning organisation, but the 7 principles really underpin the standards system in England, but also actually more widely, and we have particular responsibility for those principles.
And the committee's remit covers all holders of public office, is that right? So it's not simply central government, ministers, it's public office, public service across the nation?
It is public service across the nation, so certainly those in political and elected office, but also civil service and anybody else who is working for the public. And in an amendment to the committee's terms of reference in 2013, that was extended to include the private sector companies who are working to deliver public services.
And the committee itself has no statutory powers, is that right?
That is correct. We are not a statutory organisation.
And then how does the work of the committee interact with others who may have responsibility too for the Nolan Principles, such as the Independent Advisor on Ministers' Interests or the Parliamentary Commissioner for Standards?
In the course of the 27 years or so that this standing committee has been in existence, we have made a number of recommendations to government, and those have led to the creation of a number of the bodies which have a direct responsibility for articulating and enforcing standards in particular institutions and in other parts of public life. So, for instance, the Electoral Commission, the Parliamentary Commissioner for Standards, etc. So we have a continuing relationship with those bodies because we take an interest in the way in which the whole system works. We don't have any line management responsibility for them, but because they are working on as part of the overall, what we tend to call the tapestry of public standards bodies, we stay in touch with them so that we understand the areas where their work is working well and where there are problems, and from time to time we therefore may make recommendations for adaptation of the system or to improve the system, and then it's for the government to decide whether to accept those recommendations that we have made or otherwise.
And you've done that in the committee's most recent report, which I'll come on to in a few minutes. But just so that others listening will understand, the Parliamentary Commissioner for Standards, by way of example, will investigate allegations of breaches of the Code of Conduct for MPs, is that right?
That is correct, yes.
The Civil Service Commission, amongst others, may investigate breaches or alleged breaches of the Civil Service Code.
Correct.
And then the position in relation to investigation of breaches of the Ministerial Code is a little more complicated. That can be undertaken by the Independent Advisor on Ministers' Interests, although there currently isn't anyone occupying that post since the resignation in June of the last holder of that. But that effectively can only be done at the instigation of the Prime Minister or with the consent of the Prime Minister.
Yeah, the constitutional position is that the Prime Minister is responsible for the behaviour and the rules of the government that they head. For many years, the Prime Minister has produced a ministerial code which articulates the standards that the Prime Minister expects of ministers. It's for the Prime Minister to decide how to proceed when there are suggestions of impropriety by ministers. And there has been a non-statutory role, which is the Independent Advisor on Ministerial Interests, whose job it is to provide, as it says, advice to ministers to ensure that they are not in conflict with the code. And where there are allegations that a particular minister may have fallen short, then it is for the Prime Minister to invite the Independent Advisor on Ministerial Interests to undertake an investigation and to report to the Prime Minister. Should the Prime Minister take the view that there is not an issue to investigate, then that is currently his prerogative or her prerogative.
In terms of the continuing relevance and importance of the Nolan Principles, the committee's most recent report reaffirms the continuing significance of those principles. Is that right?
Yes, I think we have, in the evidence that we've taken, because most of the work that we do is based upon evidence taking and then drawing conclusions from that as a committee, I think all the evidence that we took suggested that there was considerable support for the Nolan Principles, that they still were a formulation which people felt articulated at a very high level the sort of behaviour that the public would expect from those who either work for them or represent them. And therefore, we believed that it was right to reaffirm those 7 principles as the guiding sort of overarching principles that all in public life should aspire to. We did consider whether there should be an 8th principle or whether we should reorganise them, but our view, I think quite strongly held, was that one of the benefits of the 7 principles is that they have been stable for the last roughly about 28 years, that they are quite widely understood, quite widely disseminated, not just in central government but also much more widely, and therefore keeping them as they are was a useful way of reaffirming the centrality that they have on standards matters.
I'm just going to ask you to look at a handful of passages from the committee's most recent report. So, Lawrence, could we have RLIT 301838, please? So this is Upholding Standards in Public Life, final report of the Standards Matter 2 review, and we can see the date at the bottom of the page, November 2021. So I know the committee is working on another piece of work at the moment, yes, and we'll come on to that in due course, but this is the committee's most recent publication.
That is correct.
And we can see a useful reminder of the principles, the Nolan Principles, 7 principles set out on that page: selflessness, integrity, objectivity, accountability, openness, honesty and leadership. Can I ask you to look in the report at, when I find the page, Lawrence, it should be the bottom of page 24, paragraph 1.18, please. Yes. So if we pick it up at the bottom of this page, the committee's report says this: high standards must be regularly championed and enforced. Though the majority of those working in the public sector share a strong sense of public service, new situations and scenarios will regularly throw up ethical challenges, and reliance on rules alone is not enough when circumstances fall between the lines of even the most tightly written codes. And then this, and it's this next sentence I wanted to ask you about: a culture of high standards where all public officials are encouraged to consider, discuss and apply the 7 principles of public life to their everyday work will help ensure such situations do not lead to oversight, negligence or errors of judgment. Do you have any observations, or does the committee have any thoughts on how that culture and the encouragement to consider, discuss, apply the 7 principles of public life to everyday work, how that can be fostered and encouraged?
Well, on the basis of this observation that we made in the report, we decided that we needed to focus particularly on this, because I think the strong view of the committee is that whilst it's very important to have rules and it's very important to have arrangements in place to enforce those rules, that actually, because of the fact that, a compliance culture alone can be rather formulaic and may not be as flexible as it needs to be given changes in the demands and the context of public service, that we need to look at how you create an environment in which people feel encouraged to act in an ethical way, that they are given the space to do so, that they can speak up if they have concerns. And the most recent work that we've been doing, and you alluded to that earlier in your remarks, has been some exploration of that. And whilst we haven't yet published that report, we have been thinking about the whole sort of, as it were, life cycle of people in public service, that at the point of recruitment, we believe that people should organisations should give consideration to the personal values of those who are coming into new roles, to make sure that they are people who want to act in the way that the 7 principles lay out, that at the point of induction, when they arrive in an organisation, that the expectation should be very clearly laid out, that within a system where most people go through an appraisal process, that one of the aspects that should be considered is not just have they delivered, but have they delivered in a way which is consistent with the principles and the ethical standards that are required, that those who are promoted should be promoted certainly on their ability to deliver, but also on the basis of the way in which they conduct themselves, and that therefore you should be encouraging those who want to see themselves as leaders within an organisation to think not just about their delivery, but also their ethical approach. We believe it's very important that there should be a culture which encourages speaking up, so not just formal whistleblowing if there is some major problem, but just an openness to talk about ethical issues and standards challenges, because I think, and my own personal experience in my previous careers, has been that if people talk about these things, very often the answers are not absolutely clear. This is right and this is wrong. I mean, if life was like that, that would make it a lot easier. But you are more likely to come to the right judgment if you are talking about these things in an open way, and you see it as part of your responsibility as a public servant to have that sort of dialogue, and therefore creating that culture of certainly having formal whistleblowing channels, but also encouragement for people to reflect on what they're doing. And so from that point of view, we are here talking about a series of steps which will help to encourage openness. The other things I'd say are that the tone from the top on these issues is critical, because people tend to take their norms from leaders, not just the people right at the top of organisations, but intermediate layers. So any kind of management development and so on should be talking about these issues as well as technical or harder skills, and that this needs to be led from the top of organisations in terms of the governance, and we have talked to those people who are involved in boards and leadership bodies to say, well, are you talking about these things? Because if you aren't, then it's unlikely that those people who work for you will see this as something that really matters.
And this piece of work that the committee is currently doing is known as Leadership in Practice, is that
Leading
right?
in Practice.
Leading in Practice. And do you know when the committee anticipates producing its report?
I think we are hoping that we will be able to produce it in January of next year.
Now, if we then just look to the next page, please, page 26, Lawrence. And it's paragraph 1.22, which identifies a theme that I wanted to just explore again a little further. So picking it up in the second sentence, multiple stakeholders criticised a perceived trend of dishonesty in politics. Such concerns suggest it is important for MPs and ministers to be able and willing to correct the record when they make errors or omissions. Correcting the record should be seen as a positive and proactive step to uphold high standards rather than an admission of failure or defeat. And then there's a reference to the ministerial code. And then if we just go over the page to paragraph 1.23, the report picks up on the theme of transparency and says the committee notes with concern the significant criticism from media and transparency NGOs of government compliance with its Freedom of Information Act obligations, openness, one of the 7 principles of public life, and then you go on to say it's important that both the letter and spirit of the law are followed. Now, one of the themes for this inquiry is about the extent to which those involved in public life, civil service, government ministers and beyond, do acknowledge where things have gone wrong, where decisions have been taken that should have been taken differently, different decisions should have been taken, and the ability of in particular, central government to learn reflectively. Does the committee have any thoughts on that issue and how that could be addressed?
I think it's very clear from the 7 principles that openness, i.e. the willingness to provide information to the public, that accountability and that leadership all would suggest that if there are problems, then in the first response should be to recognise those, to give an account of them, and, as we say in the report, where information has been misleading, that should be corrected. The 7 principles are not themselves enforceable in a compliance sense, but they give a very clear steer as to the way that individual public servants of any sort should be behaving. And against that background, accountability is pretty meaningless unless you have openness of information, because you can't call somebody to account if the facts are not known. And I think it's central to the whole democratic process that there has to be accountability, and that accountability requires openness and honesty, because otherwise accountability doesn't work.
And some of the recommendations that the committee made in this report appear designed to try and make the system for enforcement, might not be quite the right word, but promotion of adherence to the principles more robust. Is that fair?
That is fair. We took evidence from a number of people, both those who take a close interest in this in the academic sphere, those who have actually worked within the standards bodies, and on the basis of that we made a number of recommendations, including recommendations that a number of those bodies which are currently not on a statutory basis should be placed on a statutory basis. And there's a delicate balance here, because if you look, for instance, at the Independent Advisor on Ministerial Interests, we recognise that it is for the Prime Minister to lay down the standards that they expect of their ministers. But we do think that it's important that that process should be institutionalised and required. So, for instance, we recommended that the Independent Advisor there should be a statutory basis for them. We did not recommend that Parliament should decide on what the ministerial code should be, but we did believe that putting that individual post, and indeed the Commissioner for Public Appointments, onto a statutory basis would give them a much firmer foundation for the work that they did. And we were influenced, for instance, by evidence from a former Commissioner on Public Appointments that they felt their position was less strong than, for instance, the Civil Service Commission, who are on a statutory basis, and therefore we felt that this was a good time to provide a stronger foundation for a number of the standards bodies.
And if we can just look at some of those recommendations again, so that those listening can understand. Page 13, please, Lawrence. So recommendation 1 was the civil service should review its approach to enforcing ethical standards across government with a view to creating a more rigorous and consistent compliance system in line with the recommendation of the Boardman report. Again, just trying to unpick that, could you just expand upon that a little, please?
I think if you look at best practice, particularly actually more recently in the corporate sector, many companies faced with ethical challenges and reputational challenges have invested considerable amounts of resource and thinking into how to ensure that their organisation is more compliant with the values that they claim to espouse, and therefore a more robust compliance system, i.e. An arrangement to ensure that those people who are doing the job understand what is expected of them, and that if they are falling short of that, that can be identified and something can be done about it, looks to be an emerging best practice in these areas. If you look in the public sector, that is fragmentary, I would say. So there is a propriety and ethics team at the centre of government, but they are a small team. They focus particularly on almost constitutionally significant issues of standards. But if you look more widely across the civil service or beyond into the arm's length bodies and so on, there is not that compliance layer that you would see in some major firms, for instance. And it seemed to us that was a gap. And we noted with interest the recommendations made in Nigel Boardman's report, who was reporting on the the circumstances around the Greensill affair. And I think Boardman, partly because of his previous experience working with corporations, had seen the same thing, which is you can have a compliance model which is more consistent than is in place in government, and he made recommendations to that effect, which we support.
And then we can see then you tend to consider those other bodies or organisations within the system. So recommendation 2 was that there should be primary legislation to place the Independent Advisor on Ministers' Interests, Public Appointments Commissioner, the Advisory Committee on Business Appointments on a statutory basis. And you've told us about that. Recommendation 3, the Ministerial Code should be reconstituted solely as a code of conduct on ethical standards. What underpins that?
I wouldn't place huge significance on this, except that the Ministerial Code, because it has emerged, it has evolved over a long period, is a strange mixture of ethical principles on the one hand and practical arrangements for running a cabinet governance system on the other, both of which are helpful, but they make a slightly odd mix within the Ministerial Code. So we felt that it would be clearer and more evident what the fundamental values points are if you reconstitute the Ministerial Code as a code of conduct, and then you put the procedural issues about how you handle cabinet papers, etc., into separate guidance, which is probably less politically salient, but just good practice for how you make sure the cabinet government operates.
And then recommendation 4 was the requirement for the Prime Minister to issue the Ministerial Code should be enshrined in primary legislation. So is it right to understand you did not recommend that the code itself be placed on a statutory footing? Instead, the recommendation was that there should be a legal obligation on the Prime Minister to issue the Ministerial Code.
That is correct. There is some debate about whether the Ministerial Code, the extent to which Parliament should have a say in the Ministerial Code. The view of my committee was that it is for the Prime Minister to decide how they wish their cabinet colleagues to behave in terms of conduct, but it is very important that that should be codified and visible, and therefore we did recommend that the Ministerial Code should be enshrined in primary legislation, but we did not recommend that Parliament should have an active hand in saying what is in that code. Obviously, by putting it into the public domain, you are then inviting those who might be concerned to comment on it, etc. But we believe that the ownership of the code should rest with the Prime Minister.
And then recommendation 5 was to give a formal role for the independent advisor in relation to any process of revision to the code. That, I think, is self-explanatory. Recommendation 6 then was about the code detailing sanctions. What was the thinking behind that?
There has been a sort of an assumption that if somebody breaches the Ministerial Code, that they should then stand down as a minister. We felt that was actually disproportionate. Clearly, if there is a serious breach, if there are issues of honesty, then it would be appropriate for a minister to stand down. If it is a technical or minor breach, then it may be better for that to be acknowledged, for an apology to be made or whatever. And our slight concern about a sort of cliff edge was that it would deter findings which might be of a trivial nature but then lead to calls for a minister to resign. And therefore, in the same way that within the parliamentary system, minor breaches can be proportionately dealt with, we felt that there would be a lot of sense in going down the same road with the Ministerial Code. So on the basis that the present expectation, or the former expectation, was on occasions was disproportionate.
Recommendation 7 concerned the process for appointment of the independent advisor, and I don't propose to ask you further about that. If we go over the page, I just want to pick up recommendations 8 and 9. this relates to the Independent Advisor on Ministers' Interest, should be able to initiate investigations into breaches of the Ministerial Code and should have the authority to determine breaches of the Ministerial Code. And is it right to understand that what underpins those recommendations is the current situation whereby the Independent Advisor cannot independently themselves decide to initiate an investigation? They have to be invited to, and they can only advise the Prime Minister rather than actually make findings of breach.
That is correct.
And so this essentially is to give more teeth to the role of the Independent Advisor and to make the enforcement of the Ministerial Code more robust.
Yeah, the aim of these recommendations is that, as far as possible, the facts should be placed in the public domain. The response to those is, in a sense, a policy matter for the Prime Minister. But at the moment, and that I can think of individual cases where this appears to have happened, there has not been an investigation, even though it would appear that an investigation would have been an appropriate step. And I think my view and the view of my committee is that that is an unsatisfactory situation because it does not lead to accountability and it does not demonstrate openness.
And we can see recommendation 10 picks up on that by a recommendation that the Independent Advisor's findings would be published rather than simply being submitted to the Prime Minister. I'm not going to ask you about the remainder of the recommendations because they deal with matters relating to lobbying, business appointments and so on, which are obviously very important but of less relevance to this inquiry. Now, these recommendations were in a report, as we've seen, dated November 2021. Would you be right to understand that this was provided to the government with an expectation that there would be a response from government to the recommendations?
That is correct.
Has there been?
There has not been a full response. There have been responses to one or two of the a partial response to one or two of the recommendations, but we have not had a formal response to the report.
Do you have any understanding as to whether there is going to be a formal response?
I have been told that there will be a formal response and that is being worked on, although I also was told that in December, in January and subsequently.
And you have, as a committee, no power to compel a response from government?
We do not.
The last point that I wanted to ask you about, Lord Evans, is just to pick up on issues of candour and transparency again. One of the issues that has been raised in the inquiry's hearings is the role of the statutory duty of candour, which exists in the health and care setting, and the question of whether there should be a wider statutory duty of candour which bites on central government, so it would apply to civil service, to government ministers. And just to give you a little by way of background, Lord Evans, the statutory duty of candour introduced into the health and care system followed on from the Francis report, the Mid-Staffs report. And that was a report which found, amongst other things, that there was an institutional instinct to provide formulaic responses and to avoid criticism. And that was part of the thinking that then led to the statutory duty of candour. Now, it might be said that those same concerns arise in relation to the workings of central government, civil service and ministers, a desire to avoid criticism, a tendency to give formulaic responses rather than to be full and open and admit when things have gone wrong. Do you have any thoughts, or has the committee have ever considered the question of some form of statutory duty of candour?
That's not an issue that the committee has considered, and it's not an issue on which evidence has been taken. And although obviously I am aware in broad terms of the nature of that duty, it's not something on which I have any particular insight. All I would say is that if you look at the 7 Nolan principles, which include honesty, openness, accountability and leadership, then being open, being frank and being honest about where things have not gone right would be absolutely in line with those principles, and those principles are a personal responsibility for anybody in public life.
So those are the questions I was proposing to ask Lord Evans. And so I wonder if we could take a break now, perhaps for 10 minutes or so, so that I can ascertain if there are any further matters which core participants would wish me to raise.
Yes, well, let me explain, Lord Evans. A public inquiry such as this has got, as I mentioned earlier, has a number of different interests in it. There are no parties. It's not a court case. Those people who have particular interests will have been listening to what you've had to say. In particular, because there has been no witness statement, as there is with many witnesses, because the current stage of the inquiry, as you know, is looking at what we might recommend ourselves as an inquiry arising out of the facts that I consider established. They must have a chance to ask questions of you, and the law provides that they're asked in general through counsel to the inquiry. She has to have the opportunity to field those questions which arise out of what you've said, and for those who have themselves read your committee's report, and they must be given the chance to do that. I don't know how long we'll need a break for. We'll take a break and come back not before 10 to 10. That doesn't mean to say we will come back at 10 to 10, because if there's more time is needed, you'll be told. And I can't tell you how long you'll be detained after that. It depends on whether there are any questions, and if so, how many.
Thank you.
So 10, not before 10 to 10.
Thank you, sir.